Okay, well, why don't we just get on started? I know we have 30 minutes today. Hi and welcome everybody to the Seattle Propeller Club's February monthly membership meeting. For those who don't know me, my name is Tosca Pinder. I'm the co-president of the Seattle Propeller Club. The Seattle Propeller Club is one of the oldest and largest propeller clubs in the country. We host networking events and social events, something kind of like a Maritime Chamber of Commerce to promote collaboration with different sectors of the maritime industry. We're also a driving force of education to the public and promoting the maritime industry to the public. In my day job, I'm a marine insurance broker, so I'm very excited to be welcoming representatives from WARP here today to talk about USL&H cover and really what marine employers need to know about USL&H. So today we have Katie Noonan, Brad Hatfield, and April Chanez to come talk to you today. We're going to do 20-minute presentation and then a Q&A at the end. So if you guys have any questions, we'll have time to discuss those at the end. So without further ado, I will pass it over to our presenters today. And just make sure that if you're not talking, you're on mute. Thanks, guys.
And I think Cynthia is going to put up our presentation and help us by going through the slideshow. There we go. Yeah. So hi, I'm Brad Hatfield, and we want to thank Mark Gleason for inviting us and for the Propeller Club for agreeing to let us speak to you today. We're going to talk about the Longshore and Harborworkers Compensation Act. This act was originally referred to as USL&H, and more recently as the Longshore Harborworkers Compensation Act, or LHWCA. We'll use USL&H throughout this presentation for simplicity's sake, but the two terms are synonymous. By any acronym, this act and how it applies can be confusing, and we hope this presentation is helpful in improving everybody's understanding of some of the issues and we and our policyholders face on a regular basis. We have this brief presentation followed by the Q&A period that Tosca referred to. And the following people are on our panel today. Katie Noonan, who is the sales executive at Propel Insurance in Tacoma, and she is the chair of the WARP Governing Committee. I'm the executive director of WARP, and April Chanez is the senior underwriter at Alaska National Insurance Company in Seattle, and she's also the primary underwriter for all WARP business. So you can go to the next slide. So in 1992, employers and labor in the state lobbied Washington State Legislature to take action on the cost and availability of USL&H in the state. As a result, the legislature passed RCW 480270, which stated, in part, that this state hereby establishes a commission to devise and implement both a near and long-term solution to this problem of cost and availability. The state later published WAC 28422, which outlined how the RCW would be implemented. So our plan is made up of volunteers from insurance companies and insurance brokers, organized labor, and local employers, all of whom are appointed by the insurance commissioner, currently Mike Kreidler. WARP, which is how we refer to ourselves, has been self-sustaining since it started, and we pay for our operations with premiums that we collect. We contract with a servicing carrier to provide rating, policy issuance, statistical reporting, claims handling, and management services. Currently, that carrier is Alaska National, located in Seattle. Besides USL&H, the plan offers some incidental maritime employers liability coverage, subject to a limit of $100,000, but basically we're there to provide USL&H coverage. A significant portion of the risks that are written in the plan are policyholders who do not meet the minimum premium requirements of any of the private carriers in the market. So they're generally small employers, or what we would consider relatively small employers. The current average plan premium per policy is around $6,000, which for USL&H is relatively small. The plan only has one full-time employee, that's me, the director. The governing committee of volunteers meets quarterly to conduct business. Next slide, please. So very little bit of history. In 1908, the first state workers' compensation law in the United States was passed in Wisconsin. Washington state passed its version of the law in 1911, and Mississippi was the last of the states to pass such a law in 1948. In 1920, Congress adopted the Merchant Marine Act, and its Section 27 is known as the Jones Act, which, among other things, formalizes the work comp rights of seamen. In 1927, the Longshore and Harborworkers Act, USL&H, was passed. And it was later amended in 1972 and again in 1984. These amendments were designed to clear up some things, which they did, but not everything. Basically, USL&H, as it was written, attempts to solve a constitutional problem regarding the state's authority to legislate workers' compensation. USL&H covers maritime employees other than seamen who work on, over, or adjacent to the navigable waters of the United States. Next slide, please. So, USL&H is overseen by the Department of Labor through their division of Longshore and Harbor Workers' Compensation. And they administer the Act and its extensions. Those extensions include the Defense Base Act, the Outer Continental Shelf Land Act, and the Non-Appropriated Fund Instrumentalities Act. Those are federal acts that take care of other things that aren't covered by state act. We won't get into those too much today, but they're there. The Department of Labor has its main office, of course, in Washington, D.C., with multiple district offices across the country. Washington State's district office is in Seattle, and our USL&H cases, when there is a claim and it goes to court, that's heard in the Ninth Circuit Court of Appeals. The Ninth Circuit is headquartered down in San Francisco, and it is by far the largest of the country's Court of Appeals, with 29 active judges. And everyone, please note that different circuits will look at how other circuit courts across the country have ruled on certain cases, but they aren't bound by those rulings. So they'll look to see if there's precedent, but they may end up making their own precedent by their rulings. They make these different rulings on USL&H cases, and that enlarges what we refer to as the gray area in the law. Now, if a case makes its way all the way up to the Supreme Court, you can probably rely on it for a little while. Those cases have been known to change over time. Next slide, please. So as a result of what I just said, there are ambiguities in the law that April and I deal with especially April, on a kind of a regular basis. Now, we will discuss who is covered and who is excluded by USL&H in more detail in a moment. Suffice it to say that the Constitution gives the federal Congress exclusive jurisdiction in all admiralty and maritime matters. Theoretically, they do that for the sake of nationwide uniformity and consistency, but as I just mentioned, because it's a court-driven law, that kind of consistency is elusive. USL&H is a federal act, distinct from state act workers' compensation. So when you think about, I encourage you to always remember that when you pay for L&I, or Labor and Industries in Washington State, it takes care of your state act workers' compensation, but it provides no USL&H protection for your business. USL&H is very different than workers' compensation, and it's not an automatic coverage. There are only certain carriers who can write USL&H as an endorsement to their workers' compensation policy, since they must first be approved by the federal government. Now, WARP has a web page, which I'll refer to a couple of times during this presentation. You can look it up online, and I'll give you that address at the end of the presentation. And on that page, we have a list of the currently authorized carriers in the country. Next slide, please. So, for a claim to be within the jurisdiction of the USL&H Act, the accident must generally have occurred on, over, or adjacent to navigable waters of the United States. And this is often referred to as meeting the Situs test. Situs is Latin for sight, so it's just a fancy way of saying sight. Navigable waters are those which are, one, either subject to the ebb and flow of the tide, or two, currently used, previously used, or have the potential to be used to transport interstate commerce or foreign commerce. I know that's a mouthful, but basically what it says is, can there be, or has there been, interstate or foreign commerce on those waters? That's a big part of the definition of navigable. So generally, you're talking about oceans and bays, certain lakes and rivers. Oversimplified, navigable waters are used for, or are capable of being used as arteries for interstate or international commerce. And again, WARP's website provides a representative, though it's not exhaustive. We provide a representative list provided by, I believe it's the Corps of Engineers, but just keep in mind, this all gets, and ultimately gets decided in courts. But there is a representative list on our site. Adjacent to the water means on any pier or wharf or dry dock, terminal, building way, marine railway, or any adjoining other area customarily used in the loading, unloading, building, repairing, or dismantling of a vessel. So that's the situs part of the test of whether something or not is USL&H. However, there's no distinct bright line boundary determining where the state act coverage ends and longshore coverage begins. Some people talk about their work being 300 feet away from the shore's edge, for example, as a good distance to use. But it isn't that simple, unfortunately. Distance is only one factor the courts will consider. The employee's job duties may determine the appropriate jurisdiction. Each case is going to have its own facts and must be analyzed on its own. And everyone should note that the courts interpret the act liberally. What a surprise. They have found coverage as much as 3 miles from shore in certain cases, based on the activity involved. So employers who have employees engaged in full-time or part-time maritime employment are going to be subject to the USL&H Act. The term employee means any person engaged in maritime employment, including longshoremen or other person engaged in longshoring operations, and any harbor worker, including a ship repairman, a ship builder, and a ship breaker. These maritime occupations are fairly obvious, but other less obvious occupations may be subject to the Act. Next slide, please. So we should be on the slide that says who is included. It's the next one, I believe. There we go. So courts, as I mentioned, have taken a liberal or expansive interpretation of the wording of the Act, and harbor worker nowadays includes coverage, depending on the circumstances, for truck drivers, container repair workers, bulldozer operators, rail car supervisors, carpenters, fabrication shop employees, dock repairmen, mechanics who maintain loading equipment, and so forth. They have also created the concept of activities that are integral to shipbuilding to analyze which workers at a yard are covered. This has led to coverage for maintenance workers, janitors, trash collectors, tank repairmen, delivery clerks, building maintenance and repair staff, and even a worker whose job was to change air conditioning filters in a shipyard paint room. A worker who typically performs non-maritime work who is injured while performing maritime work, in other words, replacing a valve on a loading system at a marine terminal, will likely be covered. A worker who has gained this status won't lose it merely because they're performing non-marine tasks in the same facility at the time of the incident. Next slide. There we go. So now there are exclusions. There are some occupations that are exceptions to the law, either because they are listed or enumerated in the law as exceptions, or either in the original or in later revisions of the law, or they have been found to be exempt through case law. So, for example, government employees, whether federal, state, or local, or foreign, are excluded from the law. Employees who are intoxicated with alcohol or drugs may be excluded. Employees trying to harm themselves or others will generally be excluded. Go ahead to the next slide. This slide shows a variety of employees who have been shown to have little or no actual exposure to longshoring or marine construction, and they're excluded from coverage. Also, you should be aware of what is referred to as the vendor exclusion in USL&H. A subsection of the Act states that a vendor's employee is not subject to USL&H if the employee is, 1, temporarily performing services on the premises of a maritime business, or 2, is not engaged in work normally performed by employees of that maritime business, or 3, is covered by the state's workers' compensation program. So that's a lot to take in. Basically, the congressional record emphasizes that exclusions are to be narrowly construed, and narrowly construed is legalese for close adherence to the literal meaning of a text. Because of these rulings, there's probably no situation where the vendor exclusion can be applied with absolute certainty. That's why the world invented insurance brokers and insurance attorneys. At this point, for the rest of the presentation, I'll turn it over to Katie Noonan.
Thanks, Brad. So you're probably starting to get a feel for the fact that Longshore gets really confusing when you start to dig into these exclusions and who's included and who's not included. For example, is work on recreational vessels subject to Longshore? In 2009, the law changed, and it was it used to be that it depended on the size of the vessel, the work that was being done, and when they changed it in 2011, they tried to clarify it, and of course, clarifying sometimes works, sometimes doesn't. So the Department of Labor regulation defined recreational vessel in order to try and clarify what was going on. So they tried to give a general definition, a definition of vessel being built or repaired under warranty, a definition for vessel being repaired or dismantled. But again, like everything else that we've talked about, without going into the detail, just be aware that it gets very, very confusing when you're starting to have definitions being given. Go to the next slide. Courts are very expansive in their interpretation. You may at some point hear someone talk about walking in and out of coverage. Probably more accurately, they should be saying walking in and out of status, like Brad was talking about maritime status. If an analysis of the worker's overall duties reveals that any part of those duties is maritime, then they're considered a maritime employee, and therefore the company that employed them is a maritime employer. There's no moment of injury test. He or she is covered even if they're performing non-maritime duties at the time of the moment of injury. There's no walking in and out of status. The very un-PC way of putting this is you can't be kind of pregnant. You're either Longshore or you're not. Another concept, intermediate steps, you'll hear that has been cited in the past to find coverage. For example, there is a case where the US Supreme Court said that workers engaged in intermediate steps of moving cargo between the ship and land transportation, so loading a truck, were covered by the Longshore Act. So we'll go to the next slide. And things like fixed structures, a lot of times you'll hear people say for sure, drilling rigs, bridges, it just depends on the situation. You've really got to dig into what the details are of what's going on. So what is the risk of being uninsured? You don't tend to see these Department of Labor guys running around at job sites telling, oh, does everyone have their certificate? It's not something you see. So what is the risk? Well, the Longshore Act itself allows the Department of Labor to assess fines, penalties, and imprisonment against employers and their corporate officers for failing to secure Longshore Act coverage. They don't take them very often, these steps, but they could. Penalties for failing to maintain Longshore can be fines up to $10,000, the possibility of actual jail time for up to 1 year for the employer. I wanted to reinforce also the corporate officer thing, because if you've actually got a corporation, every officer in that corporation can jointly and severally also be pulled into this personally liable for not carrying Longshore. The Longshore Act also provides that an employer who fails to secure coverage cannot limit the amount of the employee's claim to the Act's compensation schedule. So you don't really have any protections that would otherwise be there under the law. And the employee can sue for damages because they're not protected by that. And they can be much larger than the compensation payments you otherwise would have had if you just had the coverage in place. A non-insured employer also cannot assert what they call affirmative defenses. Comparative negligence, meaning they contributed to the risk of what happened. Assumption of risk, that it was risky for them to undertake it. So things like that are not possible if the employer should have covered Longshore and did not. So next slide. So WARP's website, which I know we have at the end, you can actually read this tale, which is a cautionary tale about what can happen if you don't cover Longshore and should have. In this case, this was June of 2013, this jury finding for $3.45 million, plus interest of $600,000 for the time this went through. What happened was you had a vessel owner who was trying to convert a vessel into a luxury floating hotel. So he did just as you would as a vessel owner. He had his his builder's risk policy or his hull policy. He had P&I, protection and indemnity, to cover that Jones Act exposure, but did not have Longshore. There was a employee who was hired to be on board the boat, and all she was doing is she was standing on that boat throwing scrap off the side of the vessel to get rid of it. She slipped, fell into the water, and was killed. Ended up being in excess of $4 million plus legal fees. And that's not the worst part. What happened was that the vessel owner filed a notice of appeal, but the court still ordered the vessel to be sold by the federal marshals at auction, with proceeds of the sale to be paid to the claimant's estate. So the vessel owner did not recover anything from this. Now, if the owner had actually just purchased Longshore coverage, the benefits would have been paid by the insurer, by whoever the insurance company was, and the vessel owner would not have been subject to such a large judgment and probably wouldn't have lost his vessel. So again, definitely check out WARP's website if you want a little bit more detail. So actually we'll do two slides. I talked over two. There's the takeaway on this is there's no distinct boundary between where State Act and Longshore is. There's no book you can go to that tells you specifically in every circumstance what happens. The combination of the employee's job duties and where the job is taking place is always going to play into it. Businesses who have employees who are in full and part-time work can be subject to it. And be aware that there's possible exposure anytime you're doing some of this work, and make sure you keep an open dialogue with your broker. Talk to an attorney familiar with maritime law if you have to, if it's a really confusing case, which does happen. Make sure that when you're looking at jobs that you're bidding, make sure that you have these questions asked ahead of time, because sometimes it can be a surprise that it may not seem like it's a Longshore job, but the details put it into the Longshore bucket. So you don't want to bid a lower price for something and end up having it be way more expensive than you thought for the Longshore rates. Let's see there. So we'll go to the next slide. Sorry. So how can you protect yourself? Again, talk to your broker for sure. You should have a professional agent or broker working for you who understands, even if they don't understand each case, because there's a lot of case law, they know who to call. They know how to call Brad and get the question if they need to call April. If your business takes you anywhere near maritime operations, make sure you ask the question. Sometimes even if you have Jones Act coverage, you have P&I, sometimes it's not automatically protected. You may still need Longshore in place. Work with an insurance carrier who can advise you on safety programs and provide safety materials. And if possible, make sure your own risk management and safety folks are engaged in that process as well. Review all contracts and contractors you work with and make sure they have appropriate controls in place. Not everyone, even when you're working with a company, they don't necessarily always know the rules either. We've seen public entities many, many times that don't require Longshore, but Longshore is required. So it's important to be aware that you're asking these questions ahead of time. We'll go to the next slide here. So tying this all together, how can WARP help employers in Washington? So as we said, L&I doesn't handle Longshore at all. If you can't find coverage elsewhere, WARP is available. It's very easy. When you go to the website, there's an apply for coverage tab. We even tell you the rates on there for class codes, so you can see all of that information. It's very public. Applicants to the assigned risk plan are only eligible for coverage if they are unable to secure Longshore through the private insurance market. And just something I'll note, this doesn't include mutuals. Mutuals aren't included here because it's I know a common question. But if you can't find it through the private market, then WARP is available. We recommend that you do contact your broker to manage that process, because a lot of times WARP's rates are higher than what you can find elsewhere. The cost is based on the business operations. They're primarily based on payroll as opposed to hours like what L&I does. And they're based on $100 of payroll. Let's see here. And we also have a link to the full Longshore Act on the website if you have any questions or get bored and need to sleep. Longshore Act is there as well. So at this point, I think we're opening it to questions. I did actually have a few come in directly. And Jess, you are correct. That was the case. Let's see. So one question is, okay, so you have crew members or you have skippers and they're covered under P&I. Do you need Longshore if they're doing shoreside work? I'll take this one if you don't mind, Brad and April.
Go ahead. Okay.
And you guys can chime in. If you've got, that's great that you've got MEL or P&I crew coverage. If you've got those crew members or the skipper under contract as the skipper or as the crew member, that's usually how you pick them up on the P&I or on the MEL. If they're not under contract as crew or as a skipper, then it's more naturally Longshore. The thinking is when they're under contract, that when they're getting the vessel ready or locking it down at the end of the season, that it's all part of that contract and part of that assignment to the vessel. And April, I didn't know if you wanted to chime in at all. So I know you run into this question a lot.
Yeah, I would agree with the same thing. And generally what the auditors will do, I can speak to this from the WARP standpoint, and other carriers should do the same, is they actually check for crew contracts at the time. Then they're going into a situation where they know some of the crew members have participated either in, like Katie said, the lockdown or, any kind of actual maintenance and that type of thing on there. So if there's a crew contract in place, then they'll exclude them from the payroll. If there's not, then they will pick that payroll up in general. There's always extenuating circumstances to all of these cases. So, but that's usually the rule of thumb.
Perfect. The next question I'll actually give to April and Brad. I think I know the answer, but I'll let them chime in. So for volunteers, when you have volunteers working as shipboard maintenance again, and let's assume for the sake of the question that they're not under contract, but if they're volunteering for shipboard maintenance, is that something that is subject to Longshore?
No, a volunteer is not an employee under the USL&H Act. So if you have this situation in the state of Washington, the employer can actually contact the Department of Labor and Industries, and there is a situation with L&I that you can have them voluntarily covered on L&I. But they are not considered an employee for USL&H.
Hey, Katie, just to let you know, Brad's on mute. So Brad, if you have something to say, you just need to unmute yourself. We muted you because there was some back interference that was going on during Katie's presentation.
Gotcha. Thanks. And one more, does Longshore, and this is coming up quite a bit as well, does Longshore have, or is there expected to have, a communicable disease exclusion like P&I is starting to do on that side? So is it something where you're going to see a pandemic exclusion coming up?
Not that I'm aware of to this point.
Mhm. Yeah, I think it would be difficult because, you know, it's what we're seeing is when they're contracted, is it in the course of employment? I think that question has been coming up quite a bit. And so far, like if you're California presumes that if you get it, you're in the course of employment, which is creating its own issues in the work comp world. But I think, especially for Longshore, it's a little trickier, and I don't know if we've seen a lot of cases yet to be able to tell how that is being proven or disproven.
There hasn't been a lot of claims to this point. Alaska National as a company has experienced a lot with that California piece. And then, you know, the whole Jones Act versus USL&H on what is compensable is definitely different as well. So there'll be some definite differences there. I haven't heard anything about that coming through, like I said.
Perfect. Okay, can we answer any other questions?
You guys are way too easy.
I know. Did we put everybody to sleep?
It's quite easy too sometimes with the codes up there and the paragraphs of language, but no.
It is long time. Yeah.
If anybody has any questions, I know we went a little over, but I think it's all really good material to continue to hear and to be exposed to. So last call for any questions.
Okay, I got a question.
All right, there we go.
How about if they're their only employee, but they have an LLC, or it's a wholly owned a single guy doing work, but he has established for legal reasons and his entity with only him as the only employee, an LLC. Do they require Longshore?
Is he a limited liability company or is he a sole proprietor?
Limited liability.
So if he's an employee of an LLC, partners are not included and sole proprietors are not included, but LLC members are included, and they're handled just like, I'm sorry, I'm losing my headset here. They're handled the same as an executive officer would be as far as what's included.
And so if that sole owner of the LLC and the sole employee of the LLC is out doing the work on a boat, he's bound by USL&H. Yes.
And subject to minimum payrolls.
Next question. If the microwave oven goes out on your your vessel, and you call in Albert Lee Appliance, and they send a guy out and change out the brain that was in the microwave, that sounds like that would be that exclusion that Brad was talking about. Is that true? Can you exclude people like that? And where does the line stop on that?
Which exclusion specifically did you mean? The vendor's exclusion?
Vendor exclusion, yeah.
You have to make a three-pronged test to be the vendor's exclusion.
Pardon me?
There's a three-pronged test to meet the vendor's exclusion. Brad, do you want to jump in on that one a little bit more? I'm going to untangle here. Sorry, you guys.
Oh.
Yeah, so this is Albert Lee, and they don't normally go on boats at all. But the guy's got a broken microwave and needs a new display. Albert Lee sends the guy down and he plugs it in, but he slips on the gangway. Can he make a Longshore and Harborworkers claim?
Yes, he can.
I think Brad's on mute.
Okay, I can't see where his name is even come. Yes, like Katie said, he can definitely file a claim.
Mm-hmm.
But I thought that meets the third prong of the of the vendor exclusion? Somebody that doesn't normally go on a boat.
That's only one prong of the three.
Mhm.
What are the other two prongs?
I don't know if we can jump back to that.
Yeah, I was looking as well. So
That one doesn't come up that often, and I look it up every time just to make sure I've got the three right.
yeah, so employed by suppliers, transporters, or vendors, or are temporarily doing business on the premises of a maritime employer and are not engaged in work normally performed by the employees of that employer under the Act.
Okay, so that meets all three prongs.
Mhm.
Same thing with a fire extinguisher company. Same thing with a carpet layer.
Well, no, okay, so fire extinguisher, those are going to be integral to the actual vessel. So that's not just a quick and easy. If they're coming on and they're inspecting those and they're certifying those or they're installing those, we have several companies that do specifically that in the WARP program right now.
Right, and they're marine fire extinguisher guys. But if I am a cheap son of a gun and I call from the Midwest to the guy that does fire extinguishers, he never goes on a boat, and he comes on and does my fire extinguisher, he would get the vendor exclusion, correct?
I don't think you would.
He meets all three prongs.
This is where it gets really, really confusing.
Pardon me?
You know, the best thing to do, if you have anybody coming on your vessel, your commercial vessel, to do anything, you should be asking the question if they have it or not.
Well, yeah, and they say, no, I meet the vendor exclusion. I'm just going to go here and inspect your fire extinguisher. That's it. I'm just going to lay a piece of carpet. I normally lay carpets in houses. I don't go on boats, so I meet the vendor exclusion. Now, that's going to piss Friar Knowles off, and it has. And it's going to piss Gow and everybody else off, and it has. But it happens all the time. Vendor exclusion. Is it legal?
It does definitely happen. You're rolling some dice with just rolling with that, though.
So do they meet the vendor exclusion or don't they? If they don't normally go on vessels, they meet all three of your prongs.
I think you're going to get into an argument of whether what they're doing is essential to the mission of the vessel. And that's where it's going to get really tricky. So something like, okay, it's a microwave. Well, if you ask the crew members, they probably think that is essential to the mission of the vessel. Is it really essential for maritime commerce? Probably not, but you're going to have some attorney that can argue it, which means pretty much anytime you have an attorney who's going to be able to argue it, get the coverage just to be safe, because you don't know what's going to happen. But that would be it's a great example of something that I think could be argued about. We get the question a lot about cement trucks. If you're a vendor, you're just dropping off cement. Are you a vendor? You're only temporarily there. But if you've got the cement mixer and you have to help unload the cement and direct it into something on the shipyard, is that then Longshore?
I see one of the other questions that came up here is alternate employer. Yes, you can get an alternate employer extension on USL&H. We generally do that in conjunction with a waiver of subrogation for the same employer as well.
All right.
And otherwise, we can wrap it up and give you guys your day back. We really appreciate you coming on. Clearly, it is a hard topic to really dissect, and there are unfortunately a lot of gray areas with USL&H coverage, and unfortunately sometimes the answer is, well, it depends what the courts say, right? And so we do appreciate you coming on board. I see the WARP website was posted in the chat, so definitely check that out if you guys have any additional questions. Just as wrap up for club business, want to save the date for March 17th. It's our March membership meeting. We are hosting a really special event for Women's Month. We have a woman coming to speak to us who was an integral part of the Panama Canal expansion. And so it's definitely not a event you want to miss. So look out for that. Otherwise, good seeing everybody, and thank you, Katie, April, Brad. Thank you for coming today. We really appreciate it.
Thanks for having us.